oh, hey. Another Tuesday morning, sun on the flat earth's high. Another summons landed right before my very eye. The city's back again with their same old weary plea. Said my yard's a monument to everything that shouldn't be. So I head down to the courthouse, try to keep my spirits light. Judge Connie always tries to do what's right, but his patience wears so thin, I see it in his tired gaze, as he calls my name out softly through the bureaucratic haze. Oh, it's another lousy day in the courts of Boulder Town. They say the clutter's gotta go, it's bringing property values down. I nod and I agree, say I'll tackle it with grace, but that old washing machine just found a brand new hiding place. They presented photographs are rusty, swing set on its side, a collection of old tires where the weeds can freely ride, a stack of lumber promising a project yet to start, and a kiddie pool deflated, tearing at the city's heart. I explained with gentle reason, every item's got a plan. The swing sets for the grandkids when they next come to the land. The tires might be useful for a project down the track, and that lumber's gonna build, well, I haven't settled on the stack. Oh, it's another lousy day in the courts of Boulder Town. They say the clutter's gotta go, it's bringing property values down. I nod and I agree, say I'll tackle it with grace, but that old washing machine just found a brand new hiding place. Judge Khan, he sighs deep, rubs his temples with a frown, says, Mr. Law, we've been through this, round and round this town. I'm granting you more time, sir, a final chance to clear it all, and I promise him sincerely, I'll give him my best call. Oh, it's another lousy day in the courts of Boulder Town. They say the clutter's gotta go, it's bringing property values down. I nod and I agree, say I'll tackle it with grace, but that old washing machine just found a brand new hiding. So back to my luck now with this day of execution's gift. Maybe shift the rusty buckets, give the junk a little lift. The lawn still looks a battlefield, a glorious disarray, and you gotta wonder sometimes, will it ever go away? Ever go away?
Best guy.
I did the last American call. American Mr. Peterson, he's president of the courtroom. He's number 7 on the 11 a.m. calendar.
Okay. Peterson, good morning.
Good morning.
That's some big bling you got going on there.
Oh, sorry. Yes, sir. It was on my car, but it fell, and then I was like, all right, necklace.
Yeah, cool.
Thank you.
I just don't, you don't want to wear a wheel cover around your neck.
Yeah.
Pierre Morris.
Yeah, I just threw together that video, and I did as an opener. Not this one. This one is just horrible. Everybody sent it to me. Alyssa first. Oh, my God. She is insufferable. But we're going to do it. If you got cocktails, get them out, because you're going to need to get through this. Then we've got some hoarders. That's what made me do put together the Lao song.
Pierre Morris. This is her motion to set aside default.
It is indeed. And we did file
I'm here, Judge. I'm sorry. I couldn't get my phone on to work.
All right. It's her. Oh, there you are. Hello. State your name.
Pierre Morris.
All right. This is your request to set aside the default?
Yes, sir.
All right. And what's the basis? You said you were unaware of the hearing?
No, so I was aware of the hearing. I was available for the first hearing. The attorney's office reached out to me and let me know that the staff needed some to be trained and that they were looking to resolve. So I had to keep reaching out.
Yeah, nobody cares. Pay your bills.
And nobody reached out to try to come to a resolve. So when the court date did come up, I just couldn't get back in time because I am working a contract with veterans in Las Vegas right now. So that is the reason why.
Are you trolling me? Are you serious? Did you not see the bling? The bling was prominent. If you didn't see it, back up a little bit. It's on there and it's good.
That I could not make it. I do believe my Zoom hearing was denied. So that's why I need to file a motion to actually be here.
Okay. Have the funds been paid to the landlord?
So that was the situation for the court date. Just in a
Have the funds been paid? So you see what happened was no. The answer is no. They haven't. Get the hell out. I'll make this a lot faster for everybody.
agreement of what funds they're saying are owed is not
Agreeance isn't a word. Just, get a dictionary while you're making the payment and get out.
accurate.
Okay. I took a judgment, or a judgment was taken in November for $1,571.06. You're saying you don't owe that amount?
Yes, sir. That judgment was the day that I was not there. So we were supposed to try to come to a resolve. The issue actually stemmed from May.
Would come to a resolution, not a resolve. Learn English and pay your freaking bills.
And Rachel Dornbush, I did speak with her on the issue in May. She did try to correct some things that we did not come to an agreement. There was a court date scheduled for May 16th, but somehow that was dismissed. But even on the Arborwood's paperwork, they still had down that I had a balance. So we still should have been in court. So that is, I guess they didn't communicate that with their attorney because this is like all the way from May. So this issue has never been taken care of.
Your Honor,
Dornbush?
well,
Yes.
I'm looking at the ledger, and the reason that the case was dismissed is because there was a balance. I mean, there was a credit. I mean, there was nothing due and owing. So the case was dismissed for that reason. Your Honor, first and foremost, I mean, I'm going to object to the motion even proceeding because none of that was stated in the motion. The motion says I was unaware of the hearing. If there was something more that needed to be addressed as a part of this motion, Ms. Moore should have included that in the motion.
Okay, I made the mistake of actually watching this beforehand because a bunch of people sent it to me. So I wanted to know what's going on. I don't think I'm giving anything away here when I tell you she's insufferable. But the way she treats Judge Simpson at the end of this, I have zero patience for her. I'm done. I'm done from the start. Nobody yells at Judge Simpson except me. I'm the only one that's allowed. Anyone else can cram it. That's the way I feel about it.
Instead of making a false statement alleging that she was unaware of the hearing. That is verbatim what her motion says. I was unaware of the hearing, and this was only filed beyond 10 days because of the holiday. Well, if she was aware of the hearing, then she could have filed her motion on November 19th, November 20th. She could have filed it long before the holiday occurred, which prevented her allegedly from getting to the court to do it. So I'm going to object, Your Honor, that this motion hearing even moves forward on that basis. And I am going to request actual attorney's fees because the motion that was filed is clearly erroneous and a false statement was made to the court.
I actually did file more than one motion. The motion that I did file for the Zoom hearing, it was actually denied. So I did have to file another motion. And I did speak with two representatives at the court. One of the girls' name was Ashley, and they did let me know that I did have that time Two, I actually sent a paper and I took a scan of it, and I sent that in with the explanation of what was going on with the case. So I think you may have read it incorrectly. I can pull it up and I can read it to you now. But the only reason why I was not there is because we were supposed to come to a resolve and no one ever reached out. And Rachel Dornbush, when you're speaking on it was a zero balance, if you check back onto your attorney's documents, onto your client's documents on the ledger, the same day that I spoke with you and you put that credit onto my account and we did not agree on my rental rate, they went back and put a non-sufficient funds fee there. So on the same day, there was definitely a balance and we should have been in court on the 16th. They didn't communicate that with you. My rent was supposed to go up in August. I'm sorry.
There was, and I'm just to try to get the order of this, and I don't know if you've got this, Ms. Dornbush, there was, so what I have is exactly what you stated on the motion. On her request for a Zoom hearing, she just had indicated that she's currently working out of the state of Las Vegas. I was hoping to come and resolve, but I have not received a call back yet. I can get a flight after work, but I'd be late for court. Please allow me to appear via Zoom. There's a 3-hour time difference.
And so I believe that was in the Zoom request, Your Honor, that was submitted to the court the day before the hearing on, I think, November 17th at around 3:30 p.m., which was after she contacted our office on the same day. She contacted our office around 3 p.m. and was reminded of the in-person bench trial scheduled for the 18th. But her motion that was filed with the court says, I was unaware of the hearing and it's only after 10 days because of the holiday. That is false. Ms. Moore was 100% aware of the hearing.
If we're speaking on things, I'm sorry, my phone blanked out. If that may have been, I did file 2 motions. So I don't know if both of them actually came through. I can pull up the ones that I have and I can send it back into the court.
Ma'am, so I have your signature on a motion to set aside the default. And under paragraph 2, you're asking the court to set aside the judgment. And it indicates that it must be filed within 10 days of the default judgment. And then it's because, and you wrote in, I was unaware of the hearing, and it's only after 10 days because of the holiday. The first part of that.
A judge can proceed with the hearing despite minor technical deficiencies. Usually they'll seek agreement from the other side first, but sometimes they'll just override it and do it anyway. If it's a big issue, that could be appealable. So that's how it works.
It's patently false. You were aware of the hearing because you filed the request for a Zoom.
You are a big effing liar, and you're annoying.
On that, so you knew the hearing was taking place. And then you said it's after 10 days because of the holiday. I don't even get that because the judgment was on November 18th, and there's at least really 7 days, well, more than 7 days before the holiday. There was like 9 days before the holiday that you could have filed it. So,
I've got a question for her. I think you can clear all this up right here and now.
Ma'am, are you a whore?
And
I'm confused on the motion.
It did not get filed with us until December 1st was your signature, and that's when our timestamp is.
And yes, I'm not trying to cut you off. I did call in. She did let me know that I had a few more days, and she let me know that I had to file a motion. I have the emails from you guys, and I never got the $20, I guess the check thing to actually put the motion in online. So I had to have someone come up there and do it. I would have had the motion in prior to that. My Zoom hearing was denied, and I did submit a piece of paper with a lengthy information on what we're talking about. This is the same conversation that we had prior to when the other attorney decided that they needed to train staff, and we're trying to come to a resolve. So my information hasn't changed.
With the lengthy information so they could come to a resolve.
And my issue hasn't changed either. And if we would have been in court in May, because that ledger says that I had a balance.
Ma'am, trying to go back to May, Ms. Dornbush just stated you had a credit on your account, and that's why they dismissed it.
Correct. The same day, Judge. Ms. Dornbush is not acknowledging that her client put a non-sufficient funds fee and reversed that payment back onto my ledger after I spoke with her.
When are you saying that happened?
That happened on the same day.
What she is accusing them of is being incredibly competent. She got behind. They were behind. They did a payment. Then they credited a payment. And then there was a late fee. And then they credited it back. What the F do you want them to do? Not do it? I can't take her.
On 5/6 of 2025.
Do you see that on the account, Ms.
I do see that, Your Honor, and I believe I can't speak to it with certainty because I was unaware of that until Ms. Morris brought that up. But if a dismissal had already been submitted to the court, my client would have then had to motion the court to reinstate the case, number one, to try to pursue those amounts. And following that, Ms. Morris did continue to make payments on the account.
Every time I think we can't get lower. Every time. My chat proves me wrong.
In June, payments were made and credits were done to the account, leaving a balance of $50.49. And so I don't believe my client felt there was a reason to reinstate based on subsequent payments being made.
Well, sorry, I don't want to cut you off. Just to let you know, Ms. Dornbush, because I know you didn't speak to your client. I spoke to them and we were going back and forth. They ignored my phone calls, a whole lot of things. That was done probably about 2 hours after me and you had spoke. And they literally have it on the ledger. They knew about it, and it took over 30 days for them to actually correct that. And they also put a $30 late fee onto May's rent as well. So this is an issue that needed to be addressed because just like with the $2, my rent was supposed to go up in August. That's a whole 12 months. So I understand
what is her current balance?
The current balance.
Head spoke. Come on. Doesn't it just sound like nails on a chalkboard to you? Doesn't that just give you a cringe in your soul?
Your Honor, hold on. I've got to find the current ledger that I have for this case. Give me just one moment. With December, Your Honor, $2,364.19.
And ma'am, if I take everything that you're saying, how much are you saying you owe?
Honestly, Judge, there was a discrepancy in
I know
September.
that.
Okay,
so
I'm saying
you
in September.
tell me, taking out all of that, how much do you think you owe right now?
By the way, none of this bothers me if somebody has a legitimate foreign accent. If this is your second language and you're that close, good enough. Congratulations. That's difficult. Good for you. But if you were born here and raised here, you have no excuse. None.
Now,
I think I owe them around $300 from the discrepancy that the office made in September, sending out a notice, 7-day notice, saying that my rent was $360.
Did you pay December rent?
Yes, I did. I paid it into escrow at the court, and I did that with November's rent as well.
I got $700. So you're saying that if I take that $700 off, add the 300, so basically $1,000, that you're saying that there's an error on your account in the amount of $1,364.19.
Yes, it is.
Absolutely not, Your
You
Honor.
can say absolutely not.
Where
If you
is
look
that
at the
going to
first,
come from, ma'am?
so where it's coming from is my lease is supposed to start in August. They charged me a lease increase in May, June, and July. My lease is supposed to be from 8/1/2024 to.
All right, so in May, June, and July, what are you saying they charged?
They charged me $694 for lot rent.
And if you're saying that, what should it have been?
My lot rent should have been $657.
So that's about a $50 difference each of those months. That's $150.
On top of late fees.
So how many late fees?
They charge you 2 late fees per month.
Okay, so
that's
even if they did
$85 per
that,
month.
and Ms. Dornbush, maximum amount of late fees per month is what?
Your Honor, the late fees total per month is $55 that gets charged on after the 5th and $30 that gets charged on the 21st. So it's $85 a month. However, let me go look at Ms. Morris's ledger and see if she's actually making these payments timely. Because if she's not making her payments timely, whether there's a discrepancy or not, the late fee would have hit.
Okay,
So
I hear you on that. But what I'm getting at is your numbers aren't matching, because even if I take 85, give me 85 times 3, give me 85 times 4.
5 times 4, 340.
340. So I've got 150 and 340. Where else are you claiming that there's a discrepancy of some type?
Okay, so moving forward, if you look at July, well, you took that. If you said my rent was $657 in July, I went into the office. They locked my mailbox, and I have been kicked out of the customer portal to pay online. So I get charged a $10 fee with every payment.
Ma'am, listen to me.
If you look on my ledger,
listen to me. You are claiming that there is some $1,300, almost $1,400. That is a discrepancy on your account. I'm asking you for where that discrepancy is.
Okay,
you
sir.
are giving me 150. I'm not agreeing with you. I'm just saying, where are you getting these numbers?
So where I'm getting these numbers from are my ledger. It started in May. So they put a non-sufficient funds fee on the account. After they put that non-sufficient funds fee, they added that money that was owed for May, the rent, they added that onto June. I have a 7-day notice from June. It says my rent at the top of the paper is $657, but they're not putting that onto the ledger. So that is incurring a balance. They put the non-sufficient funds fee, put the 718 back onto my ledger around June 12th or June 13th. Moving forward.
Okay, so you don't know where it came from. Thank you.
We still had a balance in July. No one is trying to come to an agreement about the balance with my ledger. So it kept on incurring. Then we get to August. I go into the office. They say I owe $175. So she said.
It kept on what? Incurring? I don't even know.
Well, you know what? Since you've been locked out of your account, her name is Dana. She said you've been locked out of your account. We'll credit you those $10 fees back. I'll do 17 of them. We're going to investigate. We'll do more. Kenya just took those $170 credits off in October. Those were supposed to be taken off in August. I paid my October rent.
I figured it out. It was hard, but incurring is a cross between accruing and incurring. She doesn't know either, so she kind of did a Dr. Seuss blend of the two for that extra special stupid spice.
To the office. They told the court that they didn't have any rent. If you look at 9/6 on my 7-day notice, Kenya, the new manager, sent out a letter saying I owe $360.
Ma'am, you are telling me that there's some $1,300, $1,400. You are not telling me where those numbers are coming from. You
Okay,
have
so let me
given
rephrase
me
this,
a
Judge.
total amount
Mhm.
of $490, basically, that you're saying shouldn't be on your account.
I said there's a total, the $450, if you look at my ledger that I paid in September, that was supposed to be the total balance owing for September. That was a staff error. It was $360. I made a $450 payment to cover the late fees. So I should not have a balance. That was a staff error, not my fault. They sent me one paper in the mail and they sent another paper to the court. They also tried to steal my money order. I also submitted to the court the payments that are made on their check system. My money order from May is not in that check system. Kenya, the manager, asked me, well, did they actually input it back into the check system?
Which is number one, wrong.
I said, I don't know. So I asked her, could I have proof? So all of this, my account is screwed up since May because of these different charges. They're saying I owe $2,000, but they also charged me a late fee and my rent was in escrow.
Apparently your English has been screwed up your whole life. I think we need to address that first. How about we do a month of conjugation camp and then we come back here and try to discuss it again. This time in complete sentences.
In November, my rent was paid to the office. The only time my rent was short was in September of 2025. And that was a staff office error. That was not a tenant error. I paid what they said was owed. Then they turn around the same day and send the court the same paper with different numbers on it. That's not my fault. All of their information that they even sent into the court with my lot rent. Sometimes it's $266. Sometimes it's $391. And Rachel Dornbush, you or the rest of your colleagues never addresses it. They started my lease last year in 2024 in July. It was supposed to start in August.
Ma'am, here's the problem. Problem is your motion says none of this.
Is that my motion, a motion that I did, or did someone else do that?
I don't know.
Because I can send it back in. I can send proof back in.
Ma'am, you know, if you keep interrupting me, because I'm about done. You're not answering my question. You're not giving me the figures. You gave me some figures which amount to 490, but that doesn't even make any sense to me.
Okay. My question is, how does it not make sense for me, but it makes sense from the attorney? You're being biased.
I'm done. You're not
You're
going to
biased.
interrupt.
You're very biased.
You're not gonna keep interrupting me. Motion
Sorry,
denied.
I was never trying to interrupt you. You're very biased.
May issues. Thank you.
You're very biased and disrespectful.
I'm done.
It doesn't matter. You're disrespectful and you're very biased. You need to do your job. You don't know how to do your job. That's all.
Her. I am done. Motion denied.
Your Honor, I would request that the money is held in escrow. I think, Your Honor.
The monies held in escrow are released to plaintiff and will be applied to the account balance.
Thank you, Your Honor.
You have an attorney. You have a boss as well. You're very biased, rude, and disrespectful.
Mute her and kick her out of the meeting. Court does call the case of Arbor Woods versus Lakeisha Sanders. Lakeisha Sanders, not here. And this is non-payment. Yes, if you raise your right, do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do. For the record, Rachel Dornbush, Palace Law, on behalf of the plaintiff. Your Honor, rent retained is $3,400. I think it's a $62.66. Costs are $186 for a total due of $3,648.66. We'd ask for a default possession only judgment with writ to issue after 10 days.
Judgment to the plaintiff by default for possession. Redemption amount is in the amount requested with writ to issue in 10 days. Arbor Woods versus April Tubb Streeter. Not checked in.
Correct, but there should be a second.
Oh, and that's right.
Miss Brewster, can you hear me? Now I've lost Miss Richmond.
This is the case that inspired me to bust out the Lao song.
Miss Brewster, can you hear me?
This is actually kind of sweet. I'm warning you, but I actually need it after that last nasty hag.
Yeah. There you go. Okay. Thank you. You're welcome.
All right, Mr. and Mrs. Richmond were with me just a moment ago and I lost them. So let me keep you here. Don't go away.
Okay.
The landlord is very sweet in this. There should be another Lau hearing. There's one set, and then that he never went to, and then I haven't seen one since. But there should be another one before this is over.
I had the Richmonds and then I lost them. I wish they'd come back so we could complete our day.
It's almost like I should have edited this.
They're back.
Yeah, Lau's not with Stinky Backyard Margaret anymore.
I don't care. You put me down here. I would.
Okay. We're in.
Where do you want me at?
Right here.
Where are you going to be? He's sleeping on it.
It's not.
Wait, you get in my quick, please.
All right, welcome back. We're going to return to the matter of Terry and Larry Richmond versus Cindy Brewster. I can see Terry Richmond, I can see Larry Richmond. Is Terry still there?
Yeah,
She's here.
I'm here, but
All
Larry
right, so,
Larry knows his case better than me.
all right,
Lydia-
so both
Lydia
plaintiffs
Lydia
are
knows
here.
more than I do, so.
And Lydia Moreland, their property manager,
She's
is
here.
also present. Cindy Brewster is present. She's at the courthouse, and they put her in the conference room. This matter was filed as a termination of tenancy as a health hazard circumstance. The plaintiffs contend that this house is in deplorable condition, health hazard, failure to obtain house and yard, failure to communicate with the landlord. Defendant has lived there for some time. Takes a while to get this much accumulation. The plaintiffs filed a notice to terminate tenancy on the defendant on September 2nd. The matter was set for last Friday,
No, Monday.
November 21st, 2 weeks ago. And the following Friday was Thanksgiving. Ms. Brewster didn't show up. She had submitted a letter on November 18th from her doctor saying that she was going to be having anesthesia and he didn't want her to come to court. Well, I didn't grant an adjournment, and she didn't show up. So we had a hearing on the 21st, and the Richmonds indicated this is a hoarder house, which is in deplorable condition. The yard is in horrible condition. The house is in horrible condition, and they wish to get the defendant to vacate so they can take the house back and bring it into code compliance. Miss Brewster, what's your position?
I've been there 26 years. Yeah, it takes a lot to accumulate. The yard's fine now. I had somebody clean up the yard for me, and I'm working on the inside of the house. I have 3 or 4 rooms done and only 2 more to go. I've gotten rid of everything almost.
We can't get in, Your Honor.
I don't know. I'm no expert on the topic, but I don't believe a word that a drug addict or a hoarder says about anything. When she says I got rid of almost everything, I think she threw out one piece of chewing gum wrapper, and the rest is still there. That's what I think.
You indicated she won't let you in to inspect the premises.
Right. And I went over there with a crew and we cleaned the yard up. We had an 8-yard dump trailer and cleaned the yard up and mowed the lawn. There were 4-foot high trees in the yard. They're growing up. There were trees growing up against the house out in the center of the yard. It was a mess.
You took an 8-yard dumpster or 8 dumpsters?
8-yard dump trailer out of the yard with leaves and brush and everything else. It's just craziness. And we'd send them letters. You know, we tried working with her all we could. It just.
Oh, yeah.
So she didn't clean up the yard, you did, is that correct?
Yes, sir. Yes, sir. And Lydia hauled a pickup truck load of cardboard out of the basement. And that's definitely fire hazard.
I cleaned some of the yard, but I didn't clean all of it. Larry did most of it.
Yeah.
And I only received one.
I cleaned some of it. My ass. You didn't clean anything. This guy came out there with a crew of competent people, and they wasted a day of their lives going through, and he paid a bunch of them to clean it up. That's what happened.
1 or 2 letters about coming into the house.
We was talking.
Mr. Richmond, is the city on you for zoning enforcement?
Couldn't hear it.
Sorry, we couldn't hear you, Judge.
Is the city on you for zoning enforcement in this house?
They have been before, so we're just trying to be proactive. And plus, it's a fire hazard. When you got the basement's got a full of 1-gallon plastic containers. If there's a fire or something, a fireman can't even get in there, and the furnace wasn't working. The fact that Lydia hauled a pickup truck load of cardboard out of there shows that it was all starting over again with even more fire material, fire hazard material. It's just craziness. There's no reason that you have to hoard all this stuff, and it's of no value but to recycle.
The basement's all clean now.
But
all right, Miss Brewster, who else lives there? Anyone else or just you?
Now it's just me. It was my son, but he don't live there anymore now.
He was there this morning.
My son was.
So was Joe.
He came by to visit, and Joe came over to help me because I'm disabled and I'm on oxygen, and I can't do a whole lot.
You know, I'm telling you.
What up?
All right. Miss Brewster, why didn't you come last week? Because what your doctor told you?
Because I was out of it because of the anesthesia. All I did was sleep that day.
All right. I don't want to put you guys in a position, Mr. and Mrs. Richmond, where legal aid or other counsel is going to come back and say we didn't do this right. She did send us a letter on the 18th by her doctor indicating she was going to be under anesthesia and did not recommend that she come on the 21st. I didn't grant the adjournment. I wanted to at least try to speak to her that day. But if I grant the writ now, I may have an issue. So I'm going to take a minute. I'm going to advise you of your rights, and I'm going to set this for a second hearing. You have the right to hire an attorney. If you cannot afford one, the court must give you information about legal aid, which we already did. Legal aid is not here. You have a right to have the case heard in the county or district where the property is located, which is here in St. Joseph County. You have a right to demand a jury trial. If you wish to have a jury trial, you must tell the court at the first appearance or make the demand in writing within 5 days of the court explaining that right to you. You can use the jury demand form and file it with the court. Pay the $50 jury demand fee and make your demand within 5 days, unless the judge waives the $50 fee for your inability to pay it. This is what's called a termination of tenancy. They finally got to the end of their rope and they want you to move out. They want to take this property and clean it probably from top to bottom and re-rent it. They gave you a notice to quit back in early September. We're now in December. They have come and done a number of cleanup matters. Not you. I don't know what the inside of the house looks like, but Mr. Richmond contends you won't let him in the house to see what it looks like. We can refer the matter for mediation. That's not likely, or the parties could seek a conditional order of dismissal, and that's not likely. Ms. Brewster, I believe they're going to get the relief that they're requesting and have you move out of this house. Have you made any provision to find another place to move to?
Your Honor.
Yes.
If she cleans a place up and she lets us come in like every quarter and walk through it without stalling and doing what she did to us this time, you know, I don't want to throw anybody out. I mean, she's been around forever, but the situation is she's getting bad counsel from somebody, and they're hoarding all this stuff that they should just be thrown out in the trash. And they're not recycling it because it just builds up, and it's a fire hazard. And I'm actually looking out for her daughter, her son, and her granddaughter. I mean, it's a fire hazard.
That is really sweet. This guy is really nice. He's trying to help. He would rather she leave because it's a pain in the ass, but he knows she doesn't have any options, and he doesn't have any grand. He's not getting any grand advantage. He could rent it to somebody else if he wanted to, probably at a higher rate, but he doesn't want to see her homeless or go or be the cause of this. Having said that, he also doesn't want a bunch of crap with ordinance violations in the city and lawsuits and everything else. So he should be applauded for this.
You know?
All right, I'm going to adjourn this, and I'm going to demand or direct that you allow them to come in and do an inspection of the premises. Your testimony is you've cleaned 4 of the 7 rooms up. That's a start. I'm not sure whether I accept that or not, but we'll find out. Today is the 12th.
Tell her that Lydia will be over there on Monday, and if she's got things straightened out, we'll continue.
I'm going to continue this to December 19th,
okay.
2025 at 11:15. The Richmonds have been your landlord for 26 years. They can agree to continue to be your landlord, but they don't want this house to burn down. They don't really want to put you out the week before Christmas. So you got another week to try to get this house cleaned up. In between now and no later than next Tuesday, you need to let them come in for Monday is when Lydia will be there.
That'll be fine. Tuesday's
There'll be an inspection of the house on Monday. We'll continue the matter until next Friday and see what the circumstance is. They could allow you to stay there.
Okay.
Thank you, Your Honor.
All right. Is anyone helping you clean it up?
I'm trying to get people to help me clean up, but it's
Well, I
hard.
think your son helped junk it up. He needs to get in there and help clean it up.
Yeah, he's the only one helping him about now.
All right.
But
What's your son's name?
Corey Brewster.
Okay.
Give me
Let's
the
see what we
link.
can get done. All right, we'll address this next Friday at 11:15 a.m.
Okay,
Thank you, Ms. Brewster.
thank you.
Thanks, Your Honor.
Mr. Rich, thank you.
Okay.
All right. That's why less and less independent people are serving as small town landlords. The whole thing's getting corporatized. All right. We'll address that next week. It's been a long morning, a long afternoon, and a long week. Today's first line was called Steal My Kisses by Ben Harper. We'll be back Monday morning with another full day. Everybody, hope your temperature rises some, and we'll see you on Monday.
Next case.
There we go. Like it's Lake Wobegon over there. All right, emergency soft sit. Let's do this, people. I'm finding it now.
Breakout room.
It's a follow up to our girl soft sit
And we'll
Martini.
just bounce him back. Yep. Looks like it. Okay.
She's crazy as hell.
All right,
Let's see what she's got for us
So
today.
you've had a chance to speak with Ms. Pritikin. So I'll let Ms. Pritikin, anything to add?
Good afternoon, Your Honor. Ms. Martini was asking for a change in her release conditions. At this time, the state is not able to do that. I would need to review the cases. I think she's currently also being held on Superior Court charges.
No, I'm not. I was PR'd on everything else. This is the only cases that I'm being held on.
In any case, I can't, in the 2 seconds that we talked, I didn't have time to review the case and determine if there's grounds to change the conditions of release and the state's recommendations. I don't know if Your Honor wants to see if there's any change in conditions. From what she told me, she has been incarcerated for about a week.
Just this time.
I don't
All
know
right.
that we're any further.
All right. Thanks, Ms. Pritikin. So Ms. Martini, yeah, I also saw that I don't believe you're being held by Superior Court. But you know, I think, and I don't want to speak for the other judicial officer who imposed bail, but looking at the history of the case, I mean, there's you know, you're in custody for the probable cause hearing, and then you were released. You failed to appear for the arraignment. You were back in custody on another charge. So it seems like the only time
I did appear for the arraignment on the streets when for one of the causes, but like I said, they made it for like 3 days after my release. So then I went to it, and then it was 3 days after that they made another one, and I didn't have a phone or anything to be able to attend that one.
Okay, so how
But
about
I will not miss any other hearings. I promise you that. Like, this has been like the worst time I've ever done in jail. Like, I have nobody. I can't even use the phone. I can't talk to anybody. I have no way to contact anybody. I'm indigent. Your Honor, please, I'm begging you to just let me. I have multiple evidence in my case that I need to be able to go obtain on the streets, because I'm my own attorney, like I said, and I have nobody to do that for me.
is there a reason why you
Judge, I left the evidence at my dealer's house.
don't want an attorney? I mean, this is work that an attorney could be doing for you.
Yeah, I know, but I've had bad experience with attorneys in the past, and I just like I've been researching all this myself, and I've just been taking care of it myself. I just need to be able to get out and get that information for you, Your Honor.
Okay, so do you have a phone number where the court can reach you and send?
If you think you've had bad experiences with other attorneys, you should give my office a call. I can make it worse.
Text reminders of your court dates?
Yes.
And let me know when you're ready. Okay, what's that number?
360-561-6926.
Yeah. Okay. Can you check and see if that's one I have already?
Your Honor, I think Ms. Pritikin has made the state's position known, but I just want to reemphasize that there's been nothing to change any sort of consideration as when bail was imposed in these two cases. Superior Court, she's not being held in Superior Court. However, I've reviewed both reports, and the victim in the Superior Court case is the same as the victim in the protection order violation here, ending in 1023. And so if there were to be a change in conditions, the state's concerned, not only for general safety of the community, but also the victim in that case.
Okay. All right, thank you. Is that number we already had? Yeah. Okay. Okay. Were you receiving text reminders of your court dates on that number before?
Yes, but Matthew Davis stole my phone.
Damn
So
it, Matthew.
I have to get out and get a new phone, but yes, I can receive them on that phone.
And that's the victim in the protection
Yes.
order violations.
Yeah, it's the victim's fault. That darn Matthew stealing my phone. Probably hitting her fist with his face too. That's my guess.
Superior Court case, Your Honor.
All right. And is Kinney Road? Is that a residential address for you, or a place where you can receive mail?
That's where I was receiving mail. Yes.
Is that an address you are?
I don't know
part
if
of-
I'm allowed to be there. Like, that's where I live. He doesn't live there, but he keeps coming there and getting me arrested. Like, he lives on Lemon Road and I live on Kinney Road, but he comes there and gets me arrested. So how is that? I don't understand.
Well, if there's a protection order between the two of you.
Yeah, but how does he come to my house and get me arrested when he doesn't live there?
But that is part of how these orders work. Is you're not, and yeah. Again, I wasn't the
That's
judge.
also another change in circumstance. Like, he comes to my house and gets me arrested. You know, like.
You probably invite him over, and he tells that story, and it's believed, and you get arrested because you're violating it. That's my guess. I don't know.
All right.
I promise, Your Honor, I will not speak with him anymore. I will not accept any calls or try to contact him at all. I'm begging you, please just review these conditions or PR me, please. Like, this is, like I said, this is the worst time I've been in jail. I'm willing to do whatever I got to do to satisfy the court and work with the district attorney to resolve my cases. Please just give me this one more opportunity. And if I fail on this, like, I don't care how long you give me. I really don't.
All right. Well, how about this? All right. Hang on a second.
Notice we're light on the soft sit crap
today.
today.
Here is our computers are slow. So give me 1 second. There's a few more things I just want to look at here.
She was talking big and strong about being a soft sit yesterday, but she's tired of being in jail. So she's figured out that she needs to stop that crap right now. If you don't believe me, check out the stream from yesterday.
And ma'am, if you can't go back to that address, where are you living?
2640 Martin Way East.
And is
Andrew
that a
straightened her
friend's
out?
house, or where does that?
Yes,
address?
that's my family's house.
After she straightened him out?
Who lives there?
Brian Michael,
I mean, like your relationship to them.
my cousin.
Okay.
Brian Michael?
And I can receive mail there.
Okay. Did you get that full address? Yes. Okay, so we'll use that as the mailing address.
Here's the problem. She keeps inviting the victim over. And I'll tell you why.
Okay. All
I've
right.
got a theory.
And that's, I'm sorry, what was the address? That was here in Olympia. Martin Way. Okay. All right. So since you're going to be staying in the area, okay, what I'm going to do is, so I'm going to release you, but I'm going to
That's what's going on.
impose some heightened release conditions that require some pretrial services supervision.
Okay.
Because it seems to me that the biggest issue that I'm looking at is the failure to appear history, particularly in this case. And so I think we've got a new address for you. It is local. And so I think if there's a pretrial release requirement that keeps you in more constant communication with the court.
She won't come back.
And requires you to check in. That will help I think that will help reduce the likelihood that you'll miss court. And that also, on the other hand, though, that opens up more opportunities for bail to be reimposed, because if you start missing your check-ins with pretrial services, those are violation reports that the court could use to then reimpose bail. So I am looking at the fact that that the Superior Court, subsequent to these charges, release.
This guy is too nice. Period. End of statement. I can see it already. He's not stupid. He's a smart guy. He's a smart guy. But this is, if you've got a client that's got some shaky stuff going on, but you want to run it past somebody, this is the guy you want right here. This is the guy you're hoping for. You're like, oh, I hope I get that, judge.
You.
Yes.
And I think with some increased supervision from pretrial services, I think that might be a reasonable alternative here to.
Thank you so much, Your Honor.
So, all right. So what I'm going to do is on the matter ending in 1023, that's the protection order violation. I'm going to, I guess, not set bail in the amount of $5,000, but. So I'll release you on your own recognizance there, but I'm going to impose as a condition of pretrial release, pretrial services supervision. So you'll get a copy of a judgment sentence order, ma'am, there at the jail. It has the phone number for pretrial services.
Okay.
All right. It says you have to contact them within 48 hours, and their phone number is right there on there. Okay. Sounds
so
like
on Monday?
Yep.
Okay.
And so you'll need to spend the weekend making sure you get a good phone that you're able to utilize, because if they don't get that call from you, they're going to send in a violation report. And then you're going to have a lot of you're going to have a lot of failure to appears, and then failure to check in with pretrial services. And so you're looking at the possibility of more bail there. All right. So all other conditions remain the same, except for this pretrial services supervision requirement.
Okay.
You've got court dates already set. This was just set for a review hearing.
Yes.
Do you know your court dates?
Yes.
Okay.
A lot happened yesterday. I just want to confirm that we have court dates for both of these cases.
That's what I'm checking too.
That's the prosecutor that did the hard read on my other stream today.
This one, court dates were set.
He read the stalking text with flair.
Don't see it.
You really should see it. It's a thing of beauty.
For pretrial, what are they? I'm going to put them on the JNS.
1023.
Yeah.
It's December 7th.
Okay. And are they set at 1:30?
No, they're actually set at 10 a.m.
They're set at 10 a.m. Okay. All right. So your next court date on all your cases is December 17th at 10 a.m. You're going to get this copy of this judgment sentence order that has your next court date on that as well. So you've got to have a hard copy of that.
Okay. Thank you.
Okay. All right. So no problem. So pretrial services supervision on that. And then on the matter ending in 6853, that's the DS3, a no ignition interlock device, in which you're held on $1,000. I'm just going to PR you on that. I'm not going to add any other conditions. That's going to just be on the one case.
Okay. Thank you so much, Your Honor.
All right. Yep. Good luck, ma'am.
Your Honor,
Thank
the last
you.
thing I think that before Ms. Martini
And
leaves.
before you leave, yep.
Yeah.
Stick around here, ma'am.
As she is going to be representing herself on these cases, she'll need to be, she'll need to receive discovery. My office was working a plan to get discovery to her in the jail now that she's being released. She'll need to go to district court and speak with the PAO office in building 2. So I don't know if she knows how to get there.
Yes.
Okay. Yeah. And man, so it sounds okay. You said yes. But I was also going to suggest that when you call pretrial services, maybe
Yeah, they
just
can help
confirm.
me.
Yeah, maybe just confirm then that you know where to go and
Okay.
and all of that. Because yeah, you'll have to contact them. Yeah, on Monday. So that might be a good opportunity for you to just make sure you know where you're going to get discovery.
Thank you so much, Your Honor.
She doesn't care because she doesn't
All
plan
right,
on
not a
coming
problem.
back.
And what I didn't sign the JNS. What was the time on the 17th? 10 a.m. Okay. And you're free to be taken back there, ma'am.
Thank you.
Thank you.
Oh, sweet Jesus. What?
Sure, I just did this right. Pretrial services.
Oh, good Lord. Oh, good Lord. Subset Martini is free. She's loose in society. He let her out. I don't mean to be too, I don't even know that judge's name. I have seen him before. He's a smart guy. He's a nice guy. He's too nice. He reminds me of me 50 years ago when I had a heart. It's a long time ago, but there was a time. Okay, there really wasn't. I figured I'd just say it because you guys wouldn't know any different. It's just my AI algorithm trying to add depth to the to the profile. That's all that's going on here. I came out I came out of the womb a-hole day one. Thank you all for coming out. Behave yourselves. I am not bailing you out per usual.